So the objective of this lecture is to give you a general overview of the Court of Justice case law in the field of the European Arrest Warrant framework decision, and try also to reflect about some prospects in this field. And I'm sure you can imagine that the task is a bit complex, considering the number of judgments that have been issued by the court. This is the list of judgments that have been issued by the court since the entry into force of the framework decision on the European Arrest Warrant. I did not include the orders by the court. There are several orders, and if I had included them in the list, well, the list would have, of course, be longer. I would have around 30 decisions by the court. So you can count them. There are currently 24 judgments that have been issued by the court on the European Arrest Warrant framework decision. 24 decisions, and this shows a clear increase, so growing number of decisions issued by the court, and especially if you take a look at the year 2016, you will see that, well, 7 decisions have been issued by the court during that year, 6 under the urgent preliminary ruling procedure, so under this famous PPU, procédure préjudicielle d'urgence. Such growing number of preliminary rulings is, of course, excellent in terms of, well, the dialogue that is established by the national courts with the Court of Justice of the EU, and it's also, of course, excellent, well, for the sake of uniform interpretation of the provisions of this framework decision. Among these 24 decisions, 13 have been issued under the PPU, so urgent preliminary ruling procedure. And I will come back to this in my conclusion, because I think this is a real challenge for the Court of Justice to be able, well, to handle all of these cases under such, well, urgent procedure. 9 decisions have been issued in Grand Chamber, which means that many of these cases concerned, well, sensitive issues, and it shows also, and we will see it in a minute, that it raised fundamental questions, especially in terms of human rights protection. Which member states are the most active in establishing this dialogue with the court? Well, the champion or the winner here is the Netherlands, and so the Rechtbank Amsterdam. I'm looking at Casper van der Schaft, of course, because if you take a look at the number, well, 8 judgments have been rendered upon preliminary question raised by this Rechtbank Amsterdam. Then follows Germany with 3 or 4 requests if one considers Aragnosi and Caldararu as being 2 different cases. Then France, Belgium, Finland, Ireland, Romania, Poland, and Spain. Going back to my list of decisions, I tried to, well, establish typology or classification of all those decisions, and so I made a distinction among 6 groups of decisions. a small group with one decision about the validity of the European Arrest Warrant framework decision. Second group dealing with the extent of control by the executing authorities. And of course, all these decisions are linked in a way to the protection of human rights. A third group of decisions relates to, the interpretation of Article 4, Para 6 of the framework decision. A fourth group gathers decisions concerning the notion of judicial decision and judicial authority. A fifth group gathers decisions concerning deadlines. And last but not least, this is a last group gathering together various decisions and dealing with different issues. So I will go very quickly on this first group. You are, of course, very familiar, I suppose, with this decision. It's also the first decision that has been issued by the Court of Justice. So this famous case, ASBL Advocaten voor de Wereld. And as you know, the court confirmed the validity of the framework decision. I do not enter in further detail. So let's move directly to the second group of decisions, which concern the extent of the control to be performed by the executing authorities, and with a link, of course, with the protection of human rights. These decisions concern various issues, and especially the mandatory ground for refusal based on the Nebis in idem case, and here I'm referring to the well-known Mantello case. There are also two essential decisions about the existence of a ground for refusal based on a violation or a risk of violation of human rights. You know that there is no explicit ground for refusal in the framework decision itself on this basis, and this has always been a very sensitive and controversial question. And here, of course, the two cases are Hadoo on the one hand and Aragnosi and Caldajaru on the other. There are also cases concerning the optional ground for refusal in case of in absentia procedures, Meloni, Dvorceki, Stacek, and Tupikash. All of these are really essential as to the degree of control that must or can be performed by the executing authorities, and as to the level of mutual trust that is to be made within the EU area for penal justice. If one takes a deeper look at all these cases, I think that, of course, there is an evolution, but an evolution that can be built upon three different stages, I think. A first stage is, a stage where the court was rather indifferent or at least detached from human rights concerns, where the court really was rather focused on efficiency concerns, fight against crime concerns, and fight against impunity concerns. These are cases where there is a rather high level of mutual trust, which has been highlighted by the courts, and I think here especially about Mantello and about Hadoo, and also, but in another way, I will come back to it in a minute, about Meloni. Then comes the second stage, I think, in this evolution, where the court is really clearly searching for a right balance between concerns of efficiency and concerns relating to protection of human rights. And in this group, you can, of course, or under this stage, you can, of course, find the famous Jeremy F. case. and also the Lanigan case. Then comes a third stage, launched with the Ragnosi and Caldararu case, which in a way show a clear move towards a case law which becomes much more human rights oriented. And in this third stage, I would of course place Ragnosi and Caldararu, but also other cases such as Dvorceki, Stasiek, Tupikas, and Bob Doggy. So I will very briefly describe the Mantello case. I'm sure you know about this case. You know that this concerns preliminary questions in interpretation relating to Article 3, Para 2 of the Framework Decision, which enshrines, as you know, a mandatory ground for refusal based on the nebis in idem principle. The decision by the court in this case was especially, I would say, disappointing concerning the second question referred to it. And this question concerns the idem, the notion of the idem. And why was it disappointing? Because the Court of Justice asked the executing authority to show a very high level of mutual trust toward the issuing authority. So it required the executing authority to trust the issuing authority as to the fact that the first judicial decision that had been rendered by an Italian court was not a basis for the application of the idem in this case. And this was quite disappointing if compared with the Advocate General conclusions. So in this case, it was if but. And of course, this decision was really difficult, I think, to reconcile with the mandatory nature of that ground for refusal. Then came the so-called Hadoo case of 2013, and this was the first time when the court had to answer questions relating to the existence of a ground for refusal based on a violation or risk of violation of human rights. But here again, and I do not enter into the details, here again, this decision was rather disappointing. Why? Well, because the court restricted the questions that had been referred to it by the national courts, and it considered that it was sufficient to examine the question whether the framework decision must be interpreted as meaning that the executing authority can refuse the execution of a prosecution European arrest warrant on the grounds that the issuing judicial authorities did not hear the requested person before the arrest warrant was issued. And of course, the court responded to this question negatively, and criticisms have been addressed, a lot of criticisms have been addressed to this decision by the court, denouncing in a way the fact that the court did not seize the opportunity that it had to establish the existence of a ground for refusal on the basis of risk of infringements of human rights. And which is very representative here, I think, and which is quite symptomatic, is that you can really feel, I think, the unease or the fact that the court was really uncomfortable in answering the questions that was raised or referred to it. You know, of course, also about this famous Meloni case about conflicting standards of human rights protection. And you know that this concerns, well, preliminary questions referred to by the Spanish Constitutional Court. I'm sure you know this case, so I will not enter into many details either. I would just like to underline that, well, in a way, it's led the court to consider that mutual trust justifies that the executing member state puts aside its own vision of human rights protection. So this in order to ensure the efficiency and the applicability of the framework decision on the European Arrest Warrant. This decision by the court was much criticized, and you can find a lot of articles, academic contributions that have been written in this respect. I must say that I'm much more nuanced in this respect, because I don't see what was the alternative for the courts. So if the court wanted to ensure the EU law primacy, I think it was obliged to go in this direction. So that's why in my classification I've put Meloni into brackets, because I'm not sure whether this case really is a symbol or represents this first stage where the court focuses on efficiency concerns. I think that this was a needed step and a needed decision by the court, once again, to guarantee the principle of primacy. With the Jeremy F. case, one enters into, the second stage, if I may say so. The question was, referred to the court by the Conseil constitutionnel of France. And so this was a case, that was given much comments as well. A lot of articles were written in the newspapers and so on because of the facts of the case, but also because it was the first time that the Conseil constitutionnel of France submitted preliminary questions to the Court of Justice. And here the question was to know whether Articles 27 and 28 of the framework decision must be interpreted as precluding member states from providing for an appeal with suspensive effect against a decision to execute a European arrest warrant, or a decision giving consent to an extension of the warrant or to an onward surrender. So it was about, the possibility for the member states to provide for an appeal against these sorts of decisions. And it's really interesting to see that the Court of Justice reasons in two steps, really balancing efficiency concerns with protection of human rights concerns. So first, about the possibility of bringing such an appeal, the court considered that the framework decision makes no express provision for such a possibility, so that member states are neither prevented nor required to do so. And so it's an issue that, is left to the member states' discretion. But then the court recalls the reference to human rights in the framework decision, and really highlights the importance of the right to an effective remedy, and the whole judicialization philosophy of the framework decision, the importance of judicial control, etc. And it makes the link between this, well, judicialization, judicial control, and, well, mutual trust. And these passages of the court's decision are, of course, very important. So its conclusion in this respect is that, well, these articles 27 and 28 of the framework decision do not preclude member states from providing for an appeal, suspending the execution of the decision. And then the court comes back to efficiency concerns and reminds, of course, about the importance of respecting well, the time frame and the deadlines that are provided for in the framework decision. So in terms of the balance to be respected between efficiency and protection of human rights, this is a very interesting case. So I'm sure you know this decision by heart, or nearly. So Aragnosi and Caldararu case is, of course, a milestone in the case law of the Court of Justice. And I think that with this case, with this decision, the court has launched a third stage in the evolution I was just describing, putting really the focus on the protection of human rights. And so I will not, well, repeat the reasoning by the court, but I would just highlight the fact that, well, this two-steps approach is very important. So the court said that, well, of course, when there is evidence of a real risk of inhuman or degrading treatment of individuals detained in the issuing member state, the executing judicial authority is bound to assess the existence of that risk when it is called upon to decide on the surrender to the authorities of the issuing member states of the individual sought by European Arrest Warrant. And so two steps are then to be followed by the executing judicial authority. First, it must, well, examine whether there are deficiencies which may be systemic or generalized, or which may affect certain groups of people, or which may affect certain places of detention. So if on the basis of, well, objective elements, well, there are such deficiencies, then there is a second step to be launched, because this is not sufficient to be able to, well, refuse the execution of EAW. There is a more in concreto step, if I may say so, that has to be implemented. Because indeed, so there is a further assessment, specific and precise, to be made of whether there are substantial grounds to believe that the individual concerned will be exposed to that risk because of the conditions for his detention envisaged in the issuing member states. The court underlines the importance of, well, the dialogue between, well, the executing and the issuing authority. So the executing authority must request information to the issuing authority on the conditions in which it is envisaged that the requested person will be detained. And the issuing authority is then obliged to provide such information. If, in light of such information, the issuing authority finds that the requested person will be exposed to a real risk of inhuman or degrading treatment, then the execution of the EAW must be brought to an end. So this is how it looks. So it's a small user guide with the two different stages, which I just described being quite visible. Last words to underline that there is a pending case, Aragnosi 2, so still pending, which concerns the same person and which has been referred by the same referring court, so Bremen. And it concerns the extent of the duties of the executing authorities. Indeed, Bremen has had, difficulties in obtaining complete information on the detention conditions of Aragnosi. And so the question is to know whether the duties only concern the first prison where Aragnosi will be imprisoned, or the next detention centers or prisons as well. Other cases pertain, I think, or belong to this third stage, so with a focus on human rights protection. First on my list, Dworzecki, but also Čašek and Tupikas. The three of them concern Article 4A1, so procedures in absentia procedures. I will not enter into the details because Casper van der Schaaf will come back on these. But I would like also to mention this Bob Doggy case of 1st June 2016. In this case, Bob Doggy was a Romanian national subject to a European arrest warrant issued by a Hungarian judicial authority for prosecution purposes. He was arrested in Romania and placed in detention while waiting for a decision upon the execution of the EAW issued against him. Under Hungarian law, in cases where there is evidence that the requested person has already left the country, a simplified procedure is implemented by immediately issuing a EAW covering Hungary, so the Hungarian territory as well, and constituting also a national arrest warrant. And so in that context, the Romanian executing judicial authority released this person on bail, considering that the EAW was not valid as it was not based on a separate national arrest warrant. And so the question here was to know whether the arrest warrant, which the EAW framework decision refers in its Article 8.1, needs to be a national arrest warrant, distinct, different from the EAW, from the European arrest warrant. And if so, whether the absence of such national warrant constitutes an implicit ground for refusal to execute the EAW. The reasoning of the court is here once again very interesting. Because, well, it considers in the end that the Hungarian practice was unlawful. It uses or refers to elements of a textual nature, especially takes a look at the words used in Article 1.1 of the framework decision, and of course also at Article 8.1c. And then it's move towards elements linked to the context and the objectives pursued by the framework decision. And so it links its conclusion in a way to the philosophy lying at the basis of mutual recognition and at the basis of also of mutual trust and mutual confidence. And here again, the protection of human rights concern is clearly present because, well, it underlines the importance of having, in a way, two different controls. One at the level of the issuance of a national warrant and another one at the level of the issuance of a European arrest warrant. So, coming to the conclusions about the second group of decisions of the Court of Justice, I think that, well, they are a lot of conclusions to be drawn from this evolution. And first of all, it shows clearly that, well, the court is getting, I would say, acquiring some maturity in this field. In the very beginning, if you think about Mantello, about Hadoo, well, you could feel that the court was quite uncomfortable with all of these issues. I think it really gets more self-confidence in the field. But still, it is cautious. And if you take a look at the wording of its Aragnosi and Caldararu decision, especially one of the last points at point 104 of this decision, you will see that the court does not simply and explicitly, well, recognize the existence of a mandatory ground for refusal based on a risk of infringement of human rights. It is much more cautious. So it says, and I quote, "If the existence of that risk cannot be discounted within a reasonable time, the executing judicial authority must decide whether the surrender procedure should be brought to an end." So it does not use the words refused, which is, I think, still representative and symptomatic of, well, this cautiousness of the Court of Justice. Now, I think it's also interesting to think about the factors, the elements explaining such evolution in the Court of Justice attitude. And here, of course, I think that the link is to be made with its opinion 213. You know that in its opinion 213, the Court of Justice gave a rather negative opinion towards the draft accession agreement of the EU to the European Convention on Human Rights. So it's a very long opinion with a lot of explanations, but the idea of the court is that, well, this draft accession agreement was affecting the autonomy of the EU legal order. And one of the arguments used by the court was, well, the principle of mutual trust. And it gave to this principle the status of EU principle of fundamental importance. So I think that, well, following this opinion 213, the court had to, in a way, position itself as a real constitutional court, justifying, in a way, the autonomy of the EU legal order. Another important factor explaining this evolution is, well, few decisions by constitutional courts. And I especially refer to one decision, which is the decision issued by the Bundesverfassungsgericht on 15 December 2015, where the Bundesverfassungsgericht clearly underlines the limits of the mutual trust principle. Now, of course, there are lots of other interesting features to be highlighted in all these cases, and especially the invitation or the promotion by the court of the dialogue between the executing and issuing authorities. It's very clear in Aragnosi and Caldararu, but also in Dvorzeki and in Bob Doggy. There are still a lot of unanswered questions. You know that Aragnosi and Caldararu concern the risk of a future infringement of the prohibition of torture, inhuman and degrading treatment. What about an infringement that would already have taken place? Then, of course, I think it's, well, we can, of course, hold a fortiori reasoning in this regard. But then, what about infringement or risk of infringement of non-absolute human rights, such as fair trial, for instance? What about the risk of infringement of human rights of an individual without elements showing systemic or generalized deficiencies, deficiencies affecting certain groups of people, or without, well, elements showing deficiencies affecting certain places of detention. So what if they are risk focused, if I may say so, against one individual or concerning one individual only? What about similar issues in the case of other EU instruments implementing the mutual recognition principle? And finally, and here I make the link with well, our discussions of this morning, and especially with the contribution by David Fennelly, which is what about the impact of this case law in terms of efficiency, in terms of fight against crime, in terms of fight against impunity. This is, of course, a very interesting well, topic for future research. But I'm sure, and maybe Casper will come back to this later on, that a lot should be said or has to be said in this respect. Now, very quickly, concerning the other groups of decisions I've identified, you know about this group of judgments relating to Article 4, para 6 of the EAW framework decision. There are 4 different cases here. Simon Kozlowski, where the courts identified or clarified the term staying in or resident of the executing state. Then came Wolzenburg and Lopez da Silva, Jorge, where the question was to know whether, well, the Netherlands and French legal provisions transposing this provision of the EAW framework decision infringed the principle of non-discrimination on the ground of nationality or not. So the answer was positive in the case of the French legislation. It did infringe the principle of non-discrimination, but negative, it did not infringe the principle of non-discrimination in the case of the Dutch legislation. And there is a 4th very recent case, the so-called Poplovsky case that was already mentioned earlier. I will not detail this because Casper van der Schaft will come back to this. Just one remark about Poplavsky to underline that there is a very interesting pending case, but Casper will also come back to this later on. So the first bullet point on the slide, very at the bottom of the PowerPoint. So the Poplavsky second, if I may say so, where it will be about identifying whether the primacy principle, well, is applicable to this framework decision on the European Arrest Warrant. 4th group of judgments, and here as well I will be very, very quick. So group of judgments concerning the notion of judicial decision and of judicial authority. There are 3 different cases here. So Poltorak case, Oschelik case, and Kovalkovas case. The 3 cases well, have been introduced or referred to by the Amsterdam Rechtbank, so Casper will come back to it as well. But I would like to make just one remark to underline that, well, they are very interesting. Indeed, in Poltorak and Kovalkovas, the Court of Justice considered that the issuing authorities, in Poltorak, the Swedish police on the one hand, and in Kovalkovas, the Lithuania Ministry of Justice, were not to be considered as judicial authorities and were thus problematic, well, in terms of the philosophy of the mutual recognition principle and, well, the idea of judicialization that governed the framework decision on the European arrest warrant. So I think in the third case, Ostchelik case, it was about the question to know whether the public prosecutor's office, I'm oversimplifying it, but whether the public prosecutor's office constituted a national authority responsible for administering criminal justice. And there the court considered that, well, yes, it is such an authority, and so it's not a problem. It's not problematic in view of the judicialization philosophy of the EAW framework decision. So here, I think this case law is quite interesting, well, because the Court of Justice shows, in a way, lots of concern for this judicialization philosophy of the EAW. It's also interesting to make links with other cases concerning other aspects of mutual recognition, but dealing also with this notion of judicial decision and judicial authority. And I'm thinking especially here about Kosowski case on the nebis in idem principle, and I'm thinking also about Balash case on the framework decision on the application of mutual recognition to financial penalties. Then comes the fifth group of decisions concerning deadlines. And so here you have first the Lanigan case and the Vilkas case. And both of these have been referred to by the Irish High Court. And both concern the consequences of the non-respect of the time frame provided for by the framework decision on the European Arrest Warrant. The first one, Lanigan, concerns Article 17, dealing with deadlines for, well, the adoption of the decision to execute or not the EAW. And the second one, Vilkas, deals with Article 23 of the framework decision, so concerning the time frame for the effective surrender of a requested person. I will not dig into the details, but I think both are very interesting as well. Lanigan is very interesting because it makes the balance once more between efficiency concerns and human rights concerns. It's a very interesting case. I do not enter into the detail, but while the courts dig into the EU Charter of Fundamental Rights, especially, and makes very interesting remarks about the duration of the custody and the need, to keep it, I would say, reasonable. Vilkas is also interesting, but for another reason, because in that case, the non-respect or the delays, the non-respect of the time frame or the delays were due to, Mr. Vilkas' behaviors himself. So indeed, so the time frame that is provided for by the framework decision for the effective surrender of the individual could not be respected because of the resistance of Mr. Vilkas. And so it's very interesting to go through this decision for this reason as well. So for question relating to, I would say, distribution of responsibility in terms of non-respect for deadlines. Sixth group of decision, which gathers different decisions or dealing with various issues. Leyman and Pustovarov concerns the interpretation of Article 27, para 2 to 4 of the framework decision concerning the speciality principle. Then there is this decision of 2008 in Santesteban Goicoechea, which interprets Articles 31 and 32 of the framework decision. Melvin West, I'm sure you know about it, so about Article 28, para 2 of the framework decision concerning successive EAWs. And here the court is, well, really focused on efficiency concerns. Here the question was to know, in the case of successive EAWs, so for which EAW the executing member states had to consent to, well, the successive surrenders, if I may say so. And the Court of Justice ruled that the subsequent surrender of a person to a member state is only subject to the consent of the last executing member state. And the reasoning of the court, well, is built upon this objective of acceleration and simplification of the procedure. Last on my list is this decision in JZ concerning the notion of detention in Article 26(1) of the EAW framework decision, according to which, as you know, all periods of detention arising from the execution of EAW must be deducted from the total period of detention to be served. And so in this case, Mr. GZ was given a custodial sentence of 3 years and 2 months, but he absconded. So EAW was issued against him, and on that basis, he was then arrested in the UK. He was released on bail, but was required to stay at the address he had provided between 10 p.m. and 7 p.m. He was also obliged to appear regularly at a police station, not to apply for foreign travel documents, and to keep his mobile switched on and charged at all times. When surrendered to the Polish authorities, he requested that the period during which he was subjected to all these measures was counted for the purpose of Article 26, para 1 of the framework decision. And so, in other words, the question was to know whether these measures had to be classified or not as detention. And so, first, the court says that, well, this notion of detention must be given an autonomous and uniform interpretation throughout the EU. And I'm, well, making a resume of the reasoning by the court. It states that, well, these measures, well, are not really to be considered as detention, but that, of course, the national authorities may, well, give a broader interpretation of these words and be, in a way, more generous towards the individual concerned than what is strictly required by the framework decision itself. So it's also an interesting decision. That's it for the list of all decisions relating, strictly speaking, to the European Arrest Warrant. Now, of course, there are other decisions which can be of interest for the EAW. And here I would like to give you a few examples. First, Grunza case, which concerns the application, which concerned framework decision of 2008 on mutual recognition of judgments imposing custodial sentences. It's, well, it's about the interpretation of the condition of double criminality. And of course, this decision is important because, well, there are lessons to be drawn for, well, more generally, the principle of mutual recognition and the abolition, partial abolition of the double criminality requirements. And of course, next on my list is the Petrouin case, so I will not come back in details about this, but I would like to underline that, well, of course, this case has given rise to a lot of criticism, a lot of comments, and one of the reasons why it was so heavily criticized is because it gives the priority to EAWs on extradition requests by third countries, which raises huge problems in, well, the relations between the EU and third countries. And here I would like to, well, highlight this order by the Court of Justice of 6 September 2017 in Peter Schothofer case. Here it was about an extradition request issued by the United Arab Emirates. And two very interesting pending cases, Picciotti, concerning an extradition request by the United States of America, and Rogevicius case. And here again, it's about a Russian extradition request. But I think that Picciotti is especially very interesting because, well, it will, I think, bring the court to the limits of its reasoning in Petrouin, because, of course, the US are one of our privileged partners in the field of cooperation, judicial cooperation in criminal matters, and we have, the EU has an extradition agreement, external agreement with the USA. So will the court, well, take the opportunity to moderate a bit or to nuance a bit its Petrouin case? I suppose yes, but it's, of course, to be seen and examined in the future. Now, last point about the prospects. I already mentioned some pending cases on the European Arrest Warrant framework decision. Some of those are really important. There are others I didn't have the chance to mention earlier, such as the Piotrowski case, a very interesting case. We can come back to this later on in the discussion. That was introduced or referred to by a Belgian court, and this deals with the interpretation of the ground for refusal, the mandatory ground for refusal on the basis of the age, so Article 3, Para 3 of the framework decision. There are, of course, also interesting pending cases concerning other mutual recognition instruments. For instance, one, Gavanosov on the EIO directive, and there are a lot of pending cases on the nebis in idem principle. Important, of course, for the outlines of the mutual trust principle. So far, there is, to my knowledge, no case law on the provisions relating to the EAW in the directives on procedural guarantees. So you know that the 6 directives on procedural guarantees, translation, Mr. Duval mentioned them this morning, translation, interpretation, the SAL12 directive, and so on. You know that all of them contain provisions on the EAW procedures. To my knowledge, there is no case that have been referred to the court so far and that would interpret these provisions, but I'm sure that there will be some references for preliminary rulings in the future. I'm not aware of an infringement procedure launched by the Commission against some recalcitrant member states in terms of transposition of the EAW framework decision. But here again, of course, that would be really interesting to see how the court would interpret certain provisions of the framework decision. And there is, of course, a link to be made between some of the cases I mentioned. And for instance, if I think about these decisions by the courts, where it's in a way considered, well, the national legislations unlawful. For instance, take the decision relating to the Swedish police, which it considered as not being a judicial authority. In a way, this is, well, a good, I would say, introduction for the next stage, which could be an infringement procedure if the member state, Sweden, does not change or amend its national law on this point. And last but not least, there is, as we have seen, it's a lot of cases. This is an important pressure also on the Court of Justice. It must, in many of these cases, accept the PPU, but of course, well, there are also a lot of cases in the field of migration and asylum that must be submitted to PPU. And will it be possible, that's my question, will it be possible for the Court of Justice, well, to continue dealing with so many cases under the urgent preliminary ruling procedure, or won't it be needed to, well, establish a new rule in this respect? For instance, maybe establishing a special chamber which would focus on such files requiring PPU. Thank you very much for your attention, and I'm looking forward to your questions and comments.